Hello students, I'd like to reiterate what we discussed just some time back because we lost the connection and even the recording as well. So maybe some other students also might miss out on whatever we discussed. So just even while the others join in, I'd like to reiterate whatever we discussed in the previous recording. That is, I was talking about the assignments and the use of the IRAC method, where I stands for identification, R stands for pointing out the relevant rule or the relevant law, A stands for application, and C stands for the conclusion that needs to be drawn. One of you some time back reminded the class about what we learned during the last class. That is, we learned about the capacity to contract and minors contract and so on. And then we were doing the slides with respect to consent, right? We will directly go to that. While we were learning consent and we were on the slide of consent, we said that consent is an important element in a contract. A person should signify his assent while, giving his consent at the time of execution of the contract. What is execution? Execution is at the time of signing of the contract. A person signifies his assent or signifies his confirmation with respect to moving ahead with the contract. So therefore, consent of the parties are a very important element in a contract. Now, this consent revolves around the principle of consensus ad idem. Now, consensus ad idem means meeting of minds. Now, for a contract to be enforceable, consent expressed by the parties to the contract must be genuine. What is a genuine consent? A party is said to have expressed his or her genuine consent when the consent is freely expressed without any coercion. What is coercion? Coercion means intimidation or under, threat, where somebody threatens a person. So that's called coercion, where someone says that if you do not sign the contract, I will kill you. If you do not sign the contract, I'm going to harm your child. Coercion or duress. Now, duress is coercion, which is along with coercion, along with threat, along with intimidation. Can you see the screen? Can you see the screen?
Oh, it's yes, okay.
It's okay.
It's okay. Cannot see. It's not clear. Yes, Dr. Henry. Yes, I'm talking.
Now?
I cannot see clearly this the lesson, the text.
Can the others see?
Yes, teacher, we can see.
Okay.
Can you read it? Nema.
Okay, I'm doing that. Okay.
Go ahead.
Yeah, so we were talking about coercion. What is coercion? I said coercion means intimidation. What is intimidation? Intimidation means threatening a person. Coercion means intimidation or threatening a person. And duress is, a threat coupled with violence, where, for example, a person points out a revolver at the temple of another person and says, sign the contract. It is duress. Next is undue influence. Now, what is undue influence? Undue influence means where a party is in a position to influence the decision of another person. Like, for example, the person is in an authoritative position, like say now a doctor and a patient, or a parent and a child, or teacher or student, or lawyer and a client, where the person is able to influence the mind of the other person, that is, and he takes advantage of that relationship and exercises undue influence. So if a contract is signed under coercion, that is intimidation or threat, duress, that is intimidation, threat coupled with violence, undue influence, or even the acts or with representation, it is considered to be as not a free consent. So what is a free consent? Free consent is a genuine consent where it is free of threat, coercion, duress, undue influence, and the absence of misrepresentation. So parties must willingly enter into a contract. Thereby, the consent must be free consent for the contract to be considered as valid. Now, a party consenting to a contract would be barely consenting to abide by the provisions of the contract. But what we are concerned with here is the consent must be a free consent and not any under pressure or a mistake. For example, A agrees to marry his teacher's niece, Miss B. So A says, okay, I'm willing to marry the teacher's niece or niece. So Miss B, the name of the niece is Miss B. So now why he agrees to marry, just not to hurt the teacher, not to hurt the sentiments of the teacher. And after, because A has had a very good relation with the teacher and the teacher had very good relation with A. So A is not in a position to deny the proposal, though he is not interested in the proposal. So this is an example of undue influence. And probably A feels that if I'm good with the teacher, I will get an opportunity at the university, or probably the teacher has given him some kind of promises saying that if you marry my niece, then okay, I will give you a position in the university and so on. So A is now under undue influence. He is not influenced by his own decisions, by his own mind, but under the influence of somebody else's mind. So, and then he goes ahead and marries. So this is an example for you of undue influence. This is called as, this is an example for you for undue influence.
Yes.
Yeah.
Sure. This is this.
Yeah, now the slide is giving me trouble. I'll just come back. Just give me a moment. It's super fast. So we finished with slide 1. Now we will go to slide 2. We'll go to slide 3. Now here, just unmute your mic, please, because I can hear something in the background.
Misrepresentation, mistake.
Okay. Now here, in case of undue influence in commercial contracts, the contract is voidable in nature. That means at the option of the party who is aggrieved, the other party can cancel the contract and say that, okay, I'm not willing to proceed with the contract. Now, I've given you a definition under the Indian Contract Act because it is very clear under the Indian Contract Act of 1872, just to give you the clarity on the concept of free consent. Now, a consent is said to be free when it is not caused by coercion. I told you what is the meaning of coercion. That means threatening somebody or intimidating someone, or undue influence. I gave you the example of undue influence, or fraud, that is cheating somebody or kind of deceiving someone, or misrepresentation. I give you the example of misrepresentation before the recording. That is when a person misrepresents as he is someone else, or it is a mistake. Now, what is coercion? Coercion is the act of threatening to do or not to do something which action may by law, which action may be forbidden by law, which action is not permitted by law. So when the agreement is formed under coercion, then such an agreement or contract may be rescinded or cancelled, and the parties to the contract are released from their obligation to perform their duties as per the contract. That means when a person is threatened to sign the contract, the person has got the option to come out of the contract when it is proved in the court of law that it has been signed under some kind of a threat. So it is a unavoidable contract at the option of the aggrieved party. Then is duress. I told you the meaning of duress is coercion coupled with, or coercion along with violence. So consent that is obtained by duress, which means threatening by use of violence. Example, pointing a gun and seeking a contractual signature. So contracts under duress are invalid, however, can be validated or rendered void at the option of the agreed party. Now, here we have an interesting case of Barton versus Armstrong in 1976. There was an issue. There was a tussle or an issue between two major shareholders of the company. In Barton versus Armstrong 1976 case, there were two shareholders who were almost at loggerheads. They were angry on each other. There was a tussle going on between them. And finally, to make the long story short, the plaintiff actually threatened to kill the defendant if he did not sell his interest in the company. Now here the Privy Council held that, this court held that in those days, a plea of duress should stand even if the death threat was not the only reason for entering into a contract. The next thing is duress can be even financial duress or economical duress. So you could also call, there is another kind under duress, there is another kind of a category there, which is financial duress or even economical duress, or duress can even be financial in nature and economical nature, where the threat is pointed towards the assets of property or something that would cause an economic loss. Now, in the case of Universe Tankships of Monrovia versus ITWF 1982 case, a threat made by the workers' union in the matter of a ship while setting forth their demands on change in the circumstances was regarded as economic duress. The workers' union said they're going to cause some harm to the ship that belonged to the company. So if the management does not agree to their demands, so this is an economic duress. They're saying they're intimidating. They're trying to threaten the company, saying that if you do not comply with our demands, then we are going to cause some harm to the ship, which is going to cause some financial loss. So this is an example for you of financial duress or economical duress. Now, what is undue influence, which I already explained earlier? Now, let me substantiate it here. When consent is sought or obtained by dominating the will of the other person due to the existing relationship, then the consent is said to have been obtained by undue influence. Now, the elements that need to be proved in the defense of undue influence is that one person. What I mean by defense, I'm using the word or the term defense here in another context, in the sense that when a party is aggrieved and is not interested to proceed with the contract, he goes to the court and he says that I'm not willing to proceed with the contract because there has been undue influence. So he takes the plea of undue influence. It's rather the plea of undue influence. He presents a defense against going or proceeding with the contract. Or even if there's a case filed against him, he comes up with a defense saying that I'm not interested to go ahead with the contract because I have signed the contract under undue influence. He comes up with a plea saying that no, or a defense saying that there has been undue influence. It has not been from my mind. Now, what are the elements under undue influence? That is one person is in an authoritative position relationship and is capable of influencing another's decision. Second is the decision of the party is supplanted or displaced by the decision of the influencer. That is, one person's decision is, kind of supplemented by another person's mind, and the person keeps doing what the other person wants the person to do. Next is there is a kind of a dependency in this kind of relationship. And fourth is sometimes age factor also can be seen there. Sometimes there can be an elderly person who is influenced by, say the elderly person is all alone and has no one and no children as well. And maybe the elderly person is living with a nephew who is taking care. So sometimes the court can come to a conclusion saying that probably there has been undue influence because of the age factor of the person, and the person has gone ahead and signed the contract. Again, an example of undue influences, again, as I said earlier, it includes husband and wife, parent and child, teacher and students, doctor and patient, law and client, employer, employee, and so on. Next is, there is a US case called Krishbaum versus Dillon 1991 case, Ohio's case, where a lawyer and a banker befriended. That means they became friends with an elderly gentleman who was a widower. Widower is a person who has lost his wife. So a lawyer and a banker became befriended. That means they tried to become friends with an elderly gentleman who was a widower. That means who has lost his wife. And the lawyer drew a will naming himself, and the banker was included in the beneficiary. Now, what he does, he takes, an advantage. The lawyer and the banker takes advantage that the person is all alone. The elderly gentleman is all alone. He's a widower. He has no one. And they became friends, and they now try to put the property on their name. And the lawyer was smart enough. He drew a will that the property should come on his name. And one of the beneficiaries, he even included the banker. Why? Because, some of the finance the bank transactions are very important in property transactions. Apart from that, there may be even bank accounts. So even he included the banker so that it would ease his transactions. That is one example. Next, in RBS versus Ettridge, Lord Nicholas elucidated or explained the concept of undue influence as follows. He said that undue influence is one of the grounds of relief developed by the courts of equity, that is based on the principles of equitable justice. Courts of equity, that is the courts which operate based on the principles of equitable justice, equality as a court of conscience. So the objective is to ensure that the influence of one person or another is not abused. That means one should not abuse the position. In every life, people constantly seek to influence the decision of others. They seek to persuade those with whom they are dealing to enter into transactions, whether great or small. The law has set limits to the means properly employable for this purpose. The law will investigate the manner in which the intention to enter into the transaction was secured. If the intention was produced by an unacceptable means, then the law will not permit the transaction to stand. This means, or the means used is regarded as an exercise of improper or undue influence and hence unacceptable. Whenever the consent thus procured ought not fairly to be treated as the expression of a person's free will. So this is what he went on to explain in RBS versus Ettridge. You can write this even in your answers. If a question comes on undue influence, what Lord Nichols spoke about and how he explained the concept of undue influence in RBS versus Ettridge. And so on. He said that circumstances in which one person acquires influence over another and the manner in which influence may be exercised varies too widely to permit any more specific criterion. Next is this Australian case of Johnson versus Buttress. Here, an illiterate 67-year-old widower named Buttress, he became friends with the appellant. There's a lady there, Miss Johnson, who was a friend of his deceased wife. That means Buttress's wife, she died long back, and this guy was a widower. He was illiterate. He was 67 years old, and he got friendly with one of his wife's friends. So Miss Johnson. So shortly before his death, Buttress transferred his house and surrounding land to Miss Johnson without receiving independent legal advice. So after that, ensuing, that is after Buttress's death, that is, a man died, his son now applied to have the transfer set receiving independent legal advice. And he said that this property had to devolve on the son, and how come it went to the lady, Miss Johnson? So this was the son's problem. So he filed an application before the court to set aside this transfer, saying that it is under undue influence. But the court held that although there was no positive proof that the transfer was procured by improper exercise of any actual dominance gained by Johnson over Buttress, there was evidence of an antecedent relationship of influence over the deceased. So the deceased placed a lot of trust and confidence in Ms. Johnson and relied on her for advice on any matter of business. Thus, this through the burden of rebutting, that means to disprove or cancel the presumption of undue influence on Johnson's, to show that Buttress knew what he was doing when he made the transfer, and it was a result of his own will. And then this lady, Miss Johnson, she in fact should fail to discharge the assumption. Next is fraud. As per the Indian Contract Act, as I gave you the definition of free will or free consent for a contract. Now, they said that a consent cannot be said to be free even if it is impeded by fraud, or if there is an element or obstruction by Fraud. Fraud means with the intention of deceiving the party. That means that would be fraud, to deceive the party, to jeopardize the transaction and to deceive the person, by cheating the person. That is fraud. Next is misrepresentation. That is consent obtained through misrepresentation. It becomes voidable at the option of the party whose consent was so obtained. Here, a false representation may be made innocently also, sometimes with the honest belief so as to the truth without any intention to deceive the party. Now, just some time back here in UAE, there was a case where there was a person who tried to misrepresent. What he did was he used his kind of a relative's passport, and on the passport he attached his own photo, and after that in such a way that his name was somewhat identical, and he managed to enter the country, and he managed to marry someone, have children. And his family members used to call him with some other name, but still the wife did not doubt him, because though he misrepresented, the wife did not doubt and say that probably there are different names for this guy, and probably the family members are calling him some other names. So he misrepresented, saying that he is someone else who is working in a government department in UAE. And finally, there was a case that came up where, because he wanted to, divorce his wife, and then the matter came up before the court. And in the proceedings, they somehow found out that this is not really the guy who was working in one of the government departments, and there was a misrepresentation and fraud for which he is now held guilty. So that is one kind of misrepresentation. Sometimes misrepresentation happens also by mistaken belief, or sometimes it just happens where they honestly believe that something is right. So that is a misrepresentation. For example, in Oscar Chess Limited versus Williams, this is again an Australian case. Here in the Australian case, they had offered one person, Mr. William, offered his mother's car to a car dealer as part payment for a new car. See, he purchased a new car, and he said, okay, I will, instead of paying you, I will try to exchange my car for that value. And he says that the car is 1948 model, William says, and the date shown in the car's registration book is 1948, he says. The dealer paid William £290 for the car. Later on, it was found that this particular car, which was sold by Williams to the car dealer, was not 1948 but was 1939 model, and was worth only £175, whereas the dealer ended up paying him £290. So the car dealer claimed damages representing the difference in the value of £115 on the ground that it was a term of contract and the car was a 1948 model. But the court held that the statement that the car was a 1948 model was not a term, but an innocent misrepresentation. That means that was an honest mistake, because Mr. William just went by what was written in the car registration book, and the car belonged to the mother. He probably doesn't really know about that the car is 1939 model. So it should have been obvious to the car dealer. Why? Because the car dealer is an expert in his field. Even if the person doesn't know, the car dealer should have known. So it should have been obvious to the car dealer that William had no personal knowledge of the year the car was made and was relying on the date of whatever was mentioned in the registration book. Next is, what is a mistake? When consent to the contract is given under an erroneous belief of something to be true or without complete knowledge of the fact, then it will be considered as a mistake. So mistake can be mistake of law or mistake of fact. Mistake of law normally is not admissible as defense, especially in India, but it depends upon jurisdiction to jurisdiction. Normally, ignorance and mistake of law is not admissible. However, mistake of fact is admissible, wherein maybe it may be committed by one party or both the parties or all the parties to the contract. There can be a mistake which is committed. So such contracts are voidable in nature. Now here, next we will move on to unconscionable contract. What is unconscionable contract? Unconscionable contracts are contracts that may be made with an improper or unsound mind, such as illiteracy, or under the lack of knowledge of the subject, heavy influence of alcohol, old age, etc. Thereby, the courts refuse to enforce such contracts due to the element of unfairness in such a contract. A contract that is influenced by not a normal mind or an unsound mind or under the influence of alcohol can be termed as an unconscionable contract, and the courts will not permit such a contract normally, and they'll not allow it to be enforced because of the element of unfairness, which is quite palpable and which comes to the fore in such contracts. The two elements that come to the fore on examining such a case of unconscionable contracts are: one, lack of understanding by the party who is aggrieved or proposed, that is, with regards to the consequence of their action. So when the party is signing the contract, they're not aware basically like what is the consequence of signing the contract. Two is there is an element of oppression where the other party may be in a weak position. That means they may not have enough bargaining power. They are deprived of the bargaining power. So such contracts which have the element of lack of bargaining power, and the party is not in a position to really give its assent, and he did not know the consequence of his action, or he lacked the understanding of what is the contract about, is an unconscionable contract, and it is not enforceable normally by the courts on the principle of saying that the contract is unfair. So referring to the Australian law here, the Australian consumer law at section 20 to 22 prohibits engaging in unconscionable conduct. I've just given reference to the Australian law. The Australian consumer law, also called ACL, the Australian consumer law at sections 20 to 22 prohibits engaging in unconscionable conduct. Section 21 prohibits unconscionable conduct with respect to the supply of goods or services to a person, and section 2 of the ACL prohibits unconscionable conduct with regards to acquisition of goods or services in business transaction. However, there are different remedies that are available, such as injunction, claiming for damages, compensatory orders, and so on. But now, what is the position in USA? Now, USA again depends upon the state in the USA. For example, now in the state of Florida, unconscionable contracts, now in case it lacks direct statutory reference, so such contracts may be enforceable. It is not enforceable. However, in some states of USA, they say that unconscionable contracts are not illegal per se. That is, as it is not illegal per se. However, in Florida, they say that unconscionable contracts are unenforceable because it lacks also, or despite the lack of direct statutory reference. So matters are handled based on judicial precedents there in Florida and past cases. So by examining procedural and substantive elements in each case, that is how the matters are handled in some parts of USA, example Florida, and it depends again from jurisdiction to jurisdiction, state to state. So this is a situation of unconscionable contracts in Australia, USA, and the general perspective that I gave you in the international context. Next is the purpose or the legality of the object of the contract, or the legality of the purpose of the contract. So the purpose of the contract should be always lawful. The object of the contract should not be unlawful, should not be illegal in nature. For example, a contract to sell drugs, it is illegal. The purpose is unlawful. The object of the contract is illegal, so that is not a valid contract. Or contract to murder someone, illegal contract, and these kind of contracts attracts criminal punishment. So here, in such case, if the party is innocent, if the other party is innocent, then it must be proved in the court of law by appropriate evidence. So it's so better, be careful in any transactions and be careful in dealing with with signing of contracts. Find out the purpose, see the draft, and then execute the contract. So the purpose and the object must be clearly defined, and you can find it in the scope clause of the contract. You can find the purpose and the object in the scope clause of any contract. Now, what are the parts of a contract? Normally, this you would learn under a drafting lecture. There would be, I do not know whether it's there for you for this sem. I'm not sure quite about that. But drafting and the drafting and conveyancing, probably you will learn a little bit of this, like what are the parts of a contract. The first part of a contract, if you see a contract, the first part has the recitals. Then the recitals is actually the preliminary statements or the preamble of the contract. And the next part are the covenants. It's divided like broadly into two, the recitals and the covenants. The recital is introduction, preliminary statements with respect to the name of the parties, the addresses, what is the purpose about, the object about, and so on. And then are the covenants. The covenants are in the term, are in the in the form of terms and conditions. So terms, it includes conditions and warranties, and then it has representations. Then you have innominate terms and exclusion clauses. And breach of any of this portion of the contract, now how the court would really interpret it again varies depending upon what is the clause that is breached. So terms may be expressed or implied. Terms in a contract may be expressed or implied. What is implied? That means it can be interpreted and understood as it is already existing. How would you decipher that terms are implied in the contract, like by way of general usage, custom, practice, or by court or judicial precedents? Like for example, A and B are having commercial transactions with each other. Say A is purchasing cloth material from B for several years together on a wholesale rate, and he says that after it reaches my go down, then I'm going to release the amount to you. So that means there are several years of transaction between them. By way of usage, by way of practice, it's already understood that B can expect the amount after his consignment reaches is go down. So implied, it is understood. Sometimes even if it is not mentioned in subsequent contracts or pay orders, suppose normally it is always mentioned, but suppose if it is not mentioned, it can be considered as an implied term. So what this covenants, it includes terms, conditions of the contract, warranties, representation, innominate terms, and exclusion clauses. Now, what are the conditions? A condition constitutes significant term in a contract, and the breach of which may attract repudiation of the contract, and the aggrieved party may sue for damages. If there is a breach of an important condition in a contract, then what is the solution there? The remedy there is the party who is aggrieved by such a breach can sue for damages, can also repudiate or just terminate or cancel the contract in between, can call off the contract. That is, if a condition is breached. What happens if a warranty is breached? If a warranty in a contract is breached, it is also a covenant in a contract, but when it is breached, the aggrieved party can call for rectification of the problem, and not necessarily will repudiate the contract, but will call for rectification of the problem if the warranty is breached, and then can also sue for damages. For example, let me give you a very, very simple and a basic example. Say you go to the store and purchase any electrical item, say an iron box. So you purchase an iron box, and it's an electrical item, and the person gives you warranty saying that it's going to function perfectly for 6 months. So within 6 months, the iron box stops functioning. So now what you do? You cannot cancel the contract. You have already paid the consideration, is given the warranty card. There's no question of repudiating the contract. Now it depends upon case to case, of course, but by and large, warranty, there is no question of repudiation of the contract, but mostly the party would ask for rectification of the defect when there is breach of warranty, and two, the party might sue the person for damages. Say, for example, somebody was electrocuted while using the electrical appliance. As a result of the appliance itself is faulty in nature. So maybe the person at the most can ask for damages or claim for damages for lost time, lost business, or for whatever damage has been caused. Now, the test to understand whether a specific statement or a covenant in a contract is a condition of warranty is whether the statement or covenant hits the root of the contract. So how would you know whether a statement in a contract is a condition or warranty? So the test here is it should hit or reach to the root of the contract, the purpose and the object of the contract, and it displaces the primary understanding between the parties. So in Purcell versus Spears, it's a Queen's Bench case. Here the court held that a condition is a major term of a contract which goes to the root of the contract. So that means a condition, if it is a condition, it is a major term and it goes to the hits or to reaches the root of the contract. Root of the contract is the object of the contract or purpose of the contract. If the condition is breached, the innocent party is entitled to repudiate, that is, call off the contract, and they can also claim damages. However, now in Bettany versus Guy, again a Queen's Bench case, you'll understand what is a warranty here, the difference here. The court held that warranties are minor terms. I said conditions are significant terms. Now warranties in Bettany versus Guy was held that they are minor terms of a contract which are not central to the existence of the contract, but it revolves around the contract, it hovers around the contract, but it is not a significant term. It is an attached term. It's a kind of an additional term, a next term. And if the warranty is breached, the innocent party may claim damages, but cannot end the contract by and large, generally speaking. Now, in this case, Bettany, the facts of the case, Bettany was a singer and the person agreed by way of contract to perform as an opera singer for a period of 3 months. The singer got ill and neglected 6 days of rehearsals. So now the employer was, annoyed. He was very angry and he dismissed the singer and he, contracted the services of some other person. Now, of course, it went up to the court. There was a litigation, and here the court was of the opinion that Bettany was in breach of warranty and held that the employer was not entitled to terminate the contract. Why? Because missing rehearsals do not hit the root of the contract, and therefore it cannot be considered as the condition that has been breached, but it looks like that there is a warranty that has been breached. Next is innominate term. What is innominate terms? It's a very simple thing. Innominate terms. Innominate terms are terms which cannot be directly categorized as a condition or a warranty, something that has a hue of both, the color of both. So it cannot be categorized as a condition, as a significant term. It cannot be considered as a warranty, that it is entirely a light term. So it is something in between. It has got the hue of both. So what happens if an innominate term is breached in a contract? So the court in Hong Kong first shipping case, the court said that it substantiated, that means it elucidated, explained and said that instead of classifying the terms as condition, warranty, or innominate term, just go and look to the effect of breach. What is the effect of breach? Whether it hits to the root of the contract, whether there is a material impact or the impact is immaterial. Material, that means something significant impact, or immaterial, that is a light impact that really does not hit to the root of the contract. So the court said that in the terms as given in the slide, they said that look to the effect of breach. In case the breach is of an innominate term, whether it has a material impact, the remedy to be applied is like the breach of condition. Material impact, significant impact, so that means you can repudiate the contract and ask for damages. In case it is the breach of innominate term has an immaterial impact, that means the remedy to be applied is like that of warranty. That means you need not repudiate the contract, but ask for rectification of the defect, and also you can claim for damages. So now innominate terms, terms that are not condition, or the terms that are not warranty, it cannot be considered as a condition, it cannot be considered as warranty. So what is the terms called? If it cannot be classified as a condition, if it cannot be classified as a warranty, that means such terms are called as innominate terms. Now, in Hong Kong first shipping versus Kawasaki Kaizen Kaisha is a landmark English contract law case which introduced the concept of innominate terms. It was in this case that the concept of innominate term came up as a category between warranties and conditions. That means it's neither a warranty, you cannot call it a warranty, you cannot call it a condition. So in this case, D chartered his ship to P and was contracted to ensure that the vessel was seaworthy and in every way fitted to ordinary cargo service. Now, D failed to provide competent personnel to maintain the ship, so that it was only at sea for 8.5 weeks for the first 7 months of the charter. That means for the remaining, days, it was almost under, maintenance, and the ship was really not fit. It was not really seaworthy. in their terms. So the court held that the contract would not be terminated. Why? Since given the time remaining on the charter and D's efforts to repair the ship, P had not been substantially deprived and deprived with the whole benefit of the contract. So the term maintenance was held to be neither a condition nor a warranty, and so therefore it was regarded as an in nomine term. So that would only terminate